I think we'll get started tonight. Good evening and thank you everybody for joining us. My name is Brad Taylor and I'm the Assistant Director of the new Museum Studies program here at the University of Michigan. I'm happy to welcome you to this first installment of a year-long colloquium on issues relating to the repatriation of museum artifacts that we're calling Ownership, Appropriation, Repatriation, Museum Collections in a Changing World. One of our objectives with the colloquium is to examine issues of ownership and repatriation from vantage points that may allow the discussion to include voices that haven't been prominent in the debate thus far. I'd like to call your attention on your way out tonight to copies of this brochure that are posted out by the door. This gives an indication of the dates and topics of the remainder of the events listed in this series. Let me go through just briefly some of the topics. On October 26th, the second installment in the colloquium will be held, it's actually being sponsored by the Kelsey Museum, and will be held at Angel Hall Auditorium A at 8 o'clock. Anthony Snodgrass will be the speaker, and the title of his presentation is The Parthenon Divided. On November 18th, back in this room at 7:30, John O'Shea from the University of Michigan Museum of Anthropology will be speaking on the representation of authority in Native American repatriation cases. After the first of the year, we have a really interesting talk slated for early January. On January 13th, Lynn Morgan, who's a professor of anthropology at Mount Holyoke College, will be coming, and the title of her presentation is Ethics and the Display of Human Embryo Specimens, looking at the ethics of displaying human embryo specimens in natural history museums in different parts of the country. And in April, on April 7th, another professor from the university, Amy Stillman, will be looking at the repatriation of performance in a talk entitled Enabling Hawaiian Hula Performance, Tradition and the Repatriation of Cultural Patrimony. And the final installment in this series is not on the brochure. It's something that we settled on just yesterday morning. Professor Michael Brown from Williams College in Williamston, Massachusetts will be coming, and his presentation is called The Struggle Over Indigenous Knowledge, Museums, Ethnobotany, and the Repatriation of Plant Heritage. So as you can see, we've got lots of different interesting topics scheduled for this colloquium series this year. Pick up a brochure on your way out. We'd love to see all of you at many of those presentations. We're also pleased to use the colloquium to feature prominent individuals both from within the university and outside who have made major contributions to the repatriation issue in our time. And tonight we're really honored to welcome Dr. Patty Gerstenblith of DePaul University to inaugurate our colloquium this year. Before she begins, let me tell you a little bit about Dr. Gerstenblith. Professor Patty Gerstenblith received a BA from Bryn Mawr College, a PhD in art history and anthropology from Harvard University, and a JD from Northwestern University School of Law. Upon graduation, she clerked for the Honorable Richard D. Cudahy of the U.S. Court of Appeals for the Seventh Circuit. Patty Gerstenblith is the co-chair of the International Cultural Property Committee of the American Bar Association section on international law and practice. She also serves as faculty advisor to the DePaul LCA Journal of Art and Entertainment Law. Professor Gerstenblith was the editor-in-chief of the International Journal of Cultural Property between 1995 and 2002, and was appointed as a member of the United States Cultural Property Advisory Committee from 2000 to 2003. She's currently director of the program in Cultural Heritage Law at the College of Law at DePaul University. Dr. Gerstenblith's teaching and publications focus on the field of cultural heritage and the law and arts. She has taught courses and seminars on such subjects as art and the law, wills and trusts, intellectual property, and cultural property. Professor Gerstenblith has published extensively on the issues of cultural property, cultural heritage disputes, and the illicit arts and antiquities market. Her most recent publications include an article published in the book Legal Perspectives on Cultural Resources, titled From Steinhardt to Schultz, the McLean Doctrine and the Protection of Archaeological Sites, as well as her forthcoming book, Art, Cultural Heritage, and the Law, published by the Carolina Academic Press. Tonight's presentation, by the way, is jointly sponsored by the University of Michigan Law School, and we'd like to thank them very much for their support. Before Patty begins this evening, I'd like to thank all of you for voting to sit out this evening's presidential debates and to opt instead for our candidate of choice this evening. I can promise you an entertaining evening because we have removed the yellow tape from behind the podium, thus allowing our speaker tonight to move freely around the room. Dr. Gerstenblith has agreed to respond to direct questions from her audience and will spare you any post-debate analysis of our event and invite you to stay instead for refreshments and a chance to talk directly to our guest afterwards. Thank you again for coming. We're glad you're here. The title of Dr. Gerstenblith's presentation this evening is Ownership, Appropriation, and Restitution: The Effect of War on the Cultural Heritage of Iraq as a Case Study. Please help me in welcoming Dr. Patty Gerstenblith to the University of Michigan.
Just make sure you leave mine.
Yeah, I'm reading yours.
Okay. Brad, thank you very much, both for inviting me here to speak and also for the kind introduction. And I want to thank you also as well for coming to hear me. And maybe, although I have a lot of territory to cover tonight, maybe you'll make it home before the debates actually are over, if you're so inclined to do that. I've been asked to give an overview of what we may call the cultural heritage restitution debate, a rather difficult thing to do even in the generous time that's been allotted to me this evening. I will begin by considering some of the theoretical and historical underpinnings of this debate. Next, I will give a thumbnail sketch of the legal regime that concerns cultural heritage appropriation and restitution. Then I will turn to the subject of Iraq and consider the status of the cultural heritage there in light of what's happened in the past year and a half. Finally, I will conclude by returning to the cultural heritage debate with some thoughts in particular about the role of museums and where we can go in the future in the light of these experiences. Before I begin, I must also give a disclaimer. I guess good lawyers give disclaimers. As the introductory lecture in the colloquium series, I thought it would be nice if I could present a neutral perspective on these issues. However, I found that I cannot, and I suspect by the time my talk is over, you will know very well where I stand. Nearly 20 years ago, when the field of cultural property law was in its infancy, Professor John Henry Merriman of Stanford Law School wrote an article entitled "Two Ways of Thinking About Cultural Property." This article laid the groundwork for what has become known as cultural property law in two traditional opposing perspectives, or as I prefer, two traditional opposing perspectives, sorry. This is perhaps the best starting place for an overview of this restitution debate. The two ways proposed by Professor Merriman he called cultural internationalism and cultural nationalism. As he explained it, one way of thinking about cultural property, i.e. objects of artistic, archaeological, ethnological, or historical interest, is as components of a common human culture, whatever their place of origin or present location, independent of property rights or national jurisdiction. Another way of thinking about cultural property is as part of a national cultural heritage. This gives nations a special interest, implies the attribution of national character to objects independently of their location or ownership, and legitimizes national export controls and demands for the repatriation of cultural property. To understand more fully this dichotomy between cultural nationalism and cultural internationalism, we must examine the beginnings of the modern debate concerning restitution. The modern history of the appropriation of cultural objects began with Napoleon's wars of the late 18th and early 19th centuries. In the course of his conquest, Napoleon appropriated artworks from throughout Europe, particularly Italy, and you see here one of the works, the Laocoon, that he took from Rome, in his desire to establish Paris as the new Rome, and in so doing, he planted the seeds for restitution claims for the next 2 centuries. In fact, the failure of France to restore many of these artworks, despite what the 1815 Treaty of Vienna dictated, provided part of Hitler's justifications for his thefts of artworks during World War II, particularly the works that he stole from France. Of course, the looting of artworks has a much older history than Napoleon, going back to Roman times and probably earlier. However, such looting was done for the purposes of showing the might of the conqueror and subjugating the conquered. Napoleon's appropriations were done for different purposes and has come to be known as the rescue narrative. This justification was articulated in a petition presented to Napoleon in 1796 and signed by many of the great French artists of the day. The petition stated, "The Romans, once an uncultivated people, became civilized by transplanting to Rome the works of conquered Greece. Thus the French people, naturally endowed with exquisite sensitivity, will, by seeing the models from antiquity, train its feeling and its critical sense. The French Republic, by its strength and superiority of its enlightenment and its artists, is the only country in the world which can give a safe home to these masterpieces. All other nations must come to borrow from our art as they once imitated our frivolity." We see in this statement the modern justifications for the appropriation of cultural objects. First, the justification focuses on the benefits that will accrue to the individual or nation that takes possession of these objects. Second, at the same time, it asserts a right based on its moral or intellectual superiority. The third element is an expression of altruism. Because the possessor has a greater ability to care for the object, the possessor is in fact not acting primarily for its own benefit, but rather for the benefit of everyone else, that is, all humanity, including the original owner. Hence, we see the rescue narrative at work. The act of looting is done for the benefit of others, not just the looter. This, by the way, is one of the masterpieces, the Wedding at Cana by Veronese, that Napoleon took from Italy and that did not find its way back. It still can be seen in the Louvre today. Napoleon was not alone in cultural looting at the beginning of the 19th century. His attempt to recreate the new Rome in Paris was answered by the British desire to create London as the new Athens. Thus, the taking of the Parthenon sculptures by Lord Elgin and their later acquisition by Parliament for the British Museum fit into the political reality of the rivalry between France and Britain. The presence of the Parthenon sculptures in the British Museum has endured as the preeminent symbol of cultural heritage dispossession even until today. Lord Elgin also engaged the narrative of rescue, although he was more focused on rescuing the sculptures from other Europeans, primarily the French, who also wanted to take them, than on rescuing them from the Ottoman Turks, the vagaries of war, and even mid-20th century air pollution. Justifications often stated today for both their initial taking and subsequent retention. Yet the rescue narrative and those who believe that has universal value ignore another theme that we can trace from the time of the Roman historian Polybius, who in the 2nd century BC questioned the Romans' excessive plundering during the siege of Syracuse. Cicero elaborated on this theme in the prosecution in 70 BC of Gaius Verus, the governor of Sicily, for corruption, including pillage of both privately and publicly dedicated religious works of art. Professor Margaret Miles has traced this theme through later Roman and early European writers to the late 18th century, when Edmund Burke held up Cicero's Verrine orations as an example of the rooting out of public greed and corruption. Echoes may also be found in Byron's campaign against Parliament's purchase of the Parthenon sculptures. It is in this context that we should view the actions of the Duke of Wellington following his victory at Waterloo. Even before Napoleon's defeat, the artist and architectural theorist Quatremère de Cancy had criticized Napoleon's looting, comparing Napoleon to Verus. Quatremère believed that the best art had a universal quality and therefore could not be possessed, but ought to be held in the original context in which it was nurtured. This gives us a third way of looking at cultural property, what we may call cultural contextualism. At the end of the Napoleonic Wars, not only were the French required by the Treaty of Vienna to return artworks taken from throughout Europe, but the Duke declined the opportunity to take some portion of those works back to England as war booty. Thus, the end of the Napoleonic Wars gave us both the first large-scale repatriation of artworks and the principle that artworks did not belong to the victors. However, the French were not required to return cultural objects taken from non-European nations, particularly from Egypt, thus illustrating the use of a double standard. We can trace the ideas of Cicero through the acts of the Duke of Wellington to the founding of the modern principles of warfare as applied to cultural objects. A young Prussian soldier present at the Battle of Waterloo later studied the classics, moved to the United States, and became a law professor at Columbia University. In 1863, President Lincoln asked Francis Lieber to draft a military code of conduct for the United States Army during the Civil War. The Lieber Code distinguished public property from other types of movable property and stated that public property should not be used as war booty. This principle was picked up in the two earlier Hague Conventions of 1899 and 1907. These conventions were the relevant legal instruments for the regulation of conduct during both world wars, and were used as a basis for some of the war crimes prosecutions at the Nuremberg trials. In response to the cultural devastations of World War II, the 1954 Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict was written, the first international convention to specifically address cultural property, and the basic instrument that governs the conduct of warfare as applied to cultural property today. The rescue narrative borrows the phrase heritage of mankind from the preamble to this Hague Convention, which states, quote, damage to cultural property belonging to any people whatsoever means damage to the cultural heritage of all mankind, since each people makes its contribution to the culture of the world. This phrase was picked up by Professor Merriman as a justification for his formulation of cultural internationalism, signifying that cultural heritage belongs to all people of the world. But the use of this phrase, heritage of mankind, as expressed in the Hague Convention, to justify this view of cultural property, is, I believe, a misinterpretation. The Hague Convention simply recognizes that people throughout the world benefit from each other's cultures, and that we are linked to each other through that cultural heritage. It does not say that the objects of that heritage have no individual owner, and therefore being unowned, belong to whoever wishes to take them and is first to appropriate them. This is not a privilege granted to people throughout the world to grab each other's cultural objects, because those objects belong to an amorphous everyone, and therefore to no one. Rather, the Hague Convention and other international legal instruments place a responsibility on each nation to guard and preserve its own cultural heritage so that everyone can benefit from that act of preservation. Thus, the 19th century gave us 5 elements that are important to the modern cultural heritage debate. First is the modern concept of the nation-state and its legal recognition as the most important locus of sovereign authority. Second is the European desire, largely in fulfillment of the rescue narrative, to appropriate artworks and antiquities from elsewhere. Numerous European nations and countless individuals consistently appropriated artworks and antiquities from the Mediterranean, Near Eastern lands, and later from Asia and Africa, sometimes as a function of colonialist acquisitiveness, and sometimes accompanied by scientific and historic interest. In the United States, there has also been a persistent desire to acquire cultural objects from other parts of the world. Because the dominant culture here comes from other places, and the indigenous culture was rarely viewed with respect, it has been thought necessary to import as much cultural objects as possible. The third element that comes to us from the 19th century was the beginnings of the science of archaeology, based on stratigraphy. It is only after an understanding of stratigraphy developed toward the end of the 19th century, with the work first of Schliemann at Troy, and more particularly of Sir Flinders Petrie in Egypt, and at Tel Hasi in the Negev Desert, and continuing later with the work of Sir Mortimer Wheeler and Dame Kathleen Kenyon, that one could in fact tell the looters and the archaeologists apart. At this point, archaeological context became paramount in importance in order to achieve a full understanding and ability to reconstruct the past. This is closely allied to the fourth element, a sense of cultural context, which can apply to archaeological contexts of sites, a social context within a particular society, or even within a particular artistic context, and today we can think of a communal context that applies to the products of indigenous or tribal societies. The fifth element that we get from the 19th century was a melding of and reaction against the preceding elements. As nations became independent, they often moved to protect their heritage from foreigners. The desire to maintain cultural objects within a particular nation coalesced with the desire to protect archaeological sites from being looted. And this eventually found expression in the legal system, often through laws that limited the export of cultural objects, and also laws that vested ownership of undiscovered archaeological objects in the nation. So, for example, Greece began to devise legal protections for its heritage almost as soon as it was freed from the Ottoman yoke. By the turn of the 20th century, Turkey and Italy had enacted national ownership laws, and many other countries, including Greece, Egypt, and even the United States, had instituted legal measures that would protect their archaeological and indigenous heritages, at least to some extent, from removal to other countries. While such laws had their origins in 19th century nationalism, today their primary purpose is to deny title to the looter of artifacts. Since the looter cannot transfer a good title to the ultimate purchaser, this should discourage the purchasing of such artifacts. If the demand is reduced, because buyers will not buy, then the theory at least is that then the supply will also be reduced, and this will reduce the amount of looting of sites themselves. After the cultural devastations wreaked on Europe during World War II and the economic recovery that followed in the 1950s and 1960s, yet one more element was added to the mix, and that's the international art market. Although the market had existed for more than 200 years, it took on a significant role in the movement of artworks and antiquities. According to the rescue narrative, the market plays a vital role by providing the best distributive mechanism which determines the monetary value of these objects, and it's because of this value that the object is preserved. The past 50 years have been notable for large-scale, spectacular thefts of artworks, such as the thefts from the Isabella Stewart Gardner Museum in Boston. And you see here the Vermeer painting that was stolen from the Gardner Museum, as well as uncounted numbers of thefts of lesser well-known and lesser value works, but which are also more difficult to trace and therefore more easily sold on the market. In terms of archaeological artifacts, the looting of sites to supply the art market has plagued every country in the world and raises particular problems. This looting destroys the fragile, non-renewable context and information that these sites contain and from which we are able to reconstruct the full story of the past. In 1969, Professor Clemency Coggins documented the destruction of Maya stele in Central America and the role of the market in fostering this destruction. Her findings played a significant role in the adoption of the second significant international convention that deals with cultural heritage, the 1970 UNESCO Convention, which has a much longer name, but I won't impose it on you. To illustrate the extent of the problem of archaeological looting and the relationship to the market, I will refer quickly to two categories of ancient artifacts that have suffered extensively from the operation of the market. The first of these are the Cycladic figurines or idols of the 3rd millennium BC that come from the Cycladic islands in the Aegean. These have been very popular with collectors since the 1950s because of their eerie resemblance to modern sculpture. Doctors Chris Chippendale and David Gill have shown that approximately 90% of the known figurines have no documented provenance, which means that nothing is known of their archaeological find spot, while at the same time some 85% of Cycladic burials have been looted. As a result, there is much we will never know about the function and purpose of these figurines and the context from which they originate. Furthermore, we do not know which of these are authentic and which are not. And it's very difficult to determine this on stylistic bases when the vast majority of objects, we don't know where they came from, whether they themselves are authentic. Second category of objects is the South Italian red-figured vases studied by Professor Riccardo Elia. Professor Elia has shown that between approximately 1750 and 1980, about 9,000 such vases were discovered, while in the 12 years between 1980 and 1992 alone, over 4,000 new vases of this type appeared on the market. On average, 9 tombs yield 1 Apulian vase, and each tomb contains approximately 40 to 50 other objects. This means that during that 12-year period, some 36,000 tombs were likely looted, with many thousands of objects either sold onto the market or discarded because they were less desirable. In addition, the skeletal remains and other types of evidence of past life, such as faunal and floral remains, would have been destroyed. Professor Elia's study of Sotheby's auction catalogs during the same time period shows that 85% of the vases listed had no provenance information at all. Through these studies and others of auction house catalogs, it is now estimated, and at least some dealers openly agree, that 85 to 90% of the antiquities sold on the market have no clear documentation. There may be several possible explanations for this, but as the listing of a clear provenance would today undoubtedly help to sell an object, archaeologists assume that most of these undocumented antiquities are the product of recent site looting. With this historical background of the restitution debate, I turn now to a sketch of the U.S. domestic and international legal regimes that address the acquisition and restitution of cultural objects. The first point under the U.S. domestic legal system deals with theft, and it starts with the principle that a thief can never convey a good title to objects. And you see here the scream by Munch that was stolen just a few weeks ago from the museum in Oslo. I mentioned before the thefts from the Gardner Museum, and of course we have the example of artwork stolen during the Holocaust. This is a Degas gouache that is currently in the Art Institute of Chicago, and this is the portrait of Wally by Egon Schiele, which has been held in New York for about 6 years now and been subject to extensive amount of litigation. Under the system in the United States, as I said, a thief cannot convey a good title. And so, in theory, the original owner can always get the object back. However, there is something called the statutes of limitation, which means that if an owner of stolen property wants to recover it, he or she must do so within a certain time period. And that certain time period in most is regulated by state rather than federal law. and the states of the United States vary between 2 and 6 years generally for the recovery of stolen personal property. Therefore, you would think that most of these claims would be barred by the passage of time. However, the statutes don't tell us when the time period starts to run, when the cause of action accrues. And most courts that have addressed this question have found ways of delaying the beginning of this time period until the original owner has a way of finding out where the object is located and who actually currently possesses it, because otherwise artworks are very easily hidden or taken to different jurisdictions, and this makes it very difficult to find. Some courts, particularly in New York, have adopted what's called the demand and refusal rule, which means the cause of action doesn't start to run until the original owner finds the current possessor and demands the return, and the current possessor refuses. Other jurisdictions have adopted the discovery rule, which says basically as long as the original owner is searching diligently for the property, then again the statute of limitations doesn't run. Now, in Europe, however, there's a different rule, continental Europe. And that is that a good faith purchaser can in fact acquire title to stolen property. This allows objects to be, let's say, stolen in one country, taken to Europe, sold in Europe to a good faith purchaser who theoretically acquires good title, and then you can bring the object to the United States. And the problem the courts have addressed is whether to recognize the acquisition of good title in a European country or whether to apply the American rule, which says that a thief does not convey good title. A lot of these points are illustrated by an interesting case involving mosaics that were stolen from a church, the Kanakaria Church in northern Cyprus. In 1974, the island of Cyprus was divided, and the Greek Orthodox churches in the northern part of the island were largely looted sometime between 1974 and the end of the 1970s. This is a view of the interior of the church. This was all documented earlier through Dumbarton Oaks, and you can see I think it's up here. In the apse of the church, there were a whole series of mosaics there that depicted various figures. And here you see a close-up, and here are the roundels down here. These are the mosaics that we're talking about. Sometime in the late 1970s, these were chiseled off the church walls, and these were taken actually through Germany, and eventually some of them were sold to a dealer in Indianapolis, Peg Goldberg, who not only acquired them, she acquired them for about $1 million, turned around, tried to sell them for $20 million. Her misfortune was that she offered them to the Getty curator, Dr. Marion True, who happened to be an expert in Byzantine art, and who immediately recognized them, and who notified the Cypriot government, who then sued Goldberg to get them back. Goldberg, who had purchased them in Switzerland, tried to claim that she had acquired good title. Went through extensive litigation where the court applied both U.S. law and Swiss law, and held under U.S. law the statute of limitations had not run because Cyprus had showed diligence in trying to find the location of the mosaics. And under Swiss law, the court held that she was not a good faith purchaser because she had ignored some very obvious warning signs. But one of the other points I want to make is that when she acquired these, not only had they been chiseled off the wall, but they came off the apse, as I said, so they were curved surfaces. She decided to have the tiles reset to flatten them because she thought they'd be more easily sold. And when they were put back together, when they glued, they apparently used like crazy glue basically to glue them back together. And the mosaics are now back in Cyprus, but obviously can never be put back in the church. And this is one of the mosaics that she acquired. It's the image of Christ, and that was the original publication of it. This is how it looks now. And this is one of the apostles, Matthew. This is the original Dumbarton Oaks publication, and this was how it looks now again. So to those who say the market confers value and that protects the objects, in fact, the market can often also injure. Now, as applied to archaeological objects, I had mentioned before national ownership laws. And law in the United States has developed that if an object is owned, if the ownership of the object is vested in the national government, then it is stolen property in the other country, and the object, even if brought to the United States, retains its character as stolen property. This is illustrated by a recent case, which was the prosecution and conviction of a very prominent New York dealer called Fred Schultz. And he was convicted on one count of conspiracy, conspiring to deal in antiquities stolen from Egypt in violation of Egypt's national ownership law. Although in the United States, he was prosecuted under the National Stolen Property Act, which prohibits the interstate or international transfer of stolen property. Here you see the main object, although there was actually a group of objects, is the head of Amenhotep III. And on your left, you see the original of the statue, and what his Schultz's co-conspirator, who was a British conservator, went to Egypt, and he would cover the objects to make them look like cheap tourist trinkets, and that to make it look like this is sort of like a King Tut kind of head. Brought them out, and when they took them to England, and then he would restore them back to their original condition. In addition, the case was very interesting. In addition to upholding this notion that national ownership law creates stolen property, the case also tells us that they created or fabricated a false collection from the 1920s, attributing it to Tocqueville Perry's uncle, and they made labels, and they microwaved them, and they dipped them in tea and whatever to make it look like this was an old collection. So that gave us also a little insight into how the market works. Finally, objects that are brought into the United States in violation of U.S. customs laws, import laws, can also produce tainted objects. And here you see a gold fiale of the 4th century BC that was found in Sicily, brought into the United States, purchased by a New York collector named Michael Steinhardt. And when the object was brought in, it spent about as long as it takes to get from the Swiss-Italian border to the airport in Zurich was how long it spent in Switzerland. But they declared the country of origin as being Switzerland and lost about $1 million off the value of the piece when it was declared upon entry. So that again resulted in the seizure and forfeiture of this object. So that's, as I said, a brief notion of the domestic law that deals with cultural property. Now I turn to international law, and briefly I'll mention the two main international conventions. First, I've already mentioned both of them. First is the 1954 Hague Convention that deals with the conduct of war with respect to cultural property. And as you see here, primarily it says that parties to the convention should basically not target cultural sites and monuments during wartime, but rather they need to respect it. These obligations, however, may be waived in what's considered to be military necessity. And furthermore, the parties to the convention undertake to prohibit, prevent, and if necessary, put a stop to any form of theft, pillage, or misappropriation of cultural property. And one of the problems we'll see here when we apply this to Iraq is it's unclear which pillage and theft we're supposed to prevent. And it probably means that, for instance, the United States has an obligation to prevent pillage by its own military and not by others. The convention also sets out what can be done during occupation. It emphasizes cooperation with the local authorities, and it also says that the only time that you can take measures to preserve cultural property in occupied territory is when it's necessary to preserve the object that may have been damaged during the military action itself. Attached to the convention was the first protocol, also written in 1954, which deals with movable objects. Basically says, prohibits the removal of objects from occupied territory. And if objects are taken into custody to protect them, they need to be returned upon conclusion of hostilities or at the end of the occupation period. Another protocol was written in 1999, the second protocol, which was done primarily in response to the Balkan Wars, during which time a lot of cultural heritage was intentionally destroyed. Again, provisions on movable property. To archaeologists, the provision B down here talks about archaeological excavations are not permitted in occupied territory, save where this is strictly required to safeguard, record, or preserve cultural property. So that's a brief view of the Hague Convention. The United States, the United Kingdom, the two main parties in the coalition in Iraq, are not parties to the convention, although they did sign it. There's a difference between being a signatory and a party. However, we claim to follow the principles of the Hague Convention that are part of customary international law. But basically, we get to decide what's customary international law, and we pick and choose, or I should say our military picks and chooses which parts it wants to follow and which parts it doesn't follow. The other main convention is the 1970 UNESCO Convention, which can apply either during wartime or peacetime. It's primarily response to the art market problems that I mentioned earlier. The two main provisions the United States has adopted, first of all, prohibits the import of stolen cultural property that was documented in the inventory of a museum or similar public institution. Second, Article 9 of the Convention calls on member states to assist others in cases of pillage of archaeological and ethnological objects. Now, the United States created a very elaborate process for entering into additional agreements on a country-by-country basis that effectuates Article 9. I won't go through the process. It's very elaborate. If anyone has a question, I'll be glad to talk about it. But there's a whole series of requirements, which are listed here, that the other country must establish, must provide evidence of, in order for us to enter into this supplementary bilateral agreement. Although we are a party, and most of the other countries that are parties to the UNESCO Convention automatically recognize each other's export restrictions. Only the United States and now Switzerland, which has just recently ratified the convention, requires this additional process. This obviously imposes burdens on countries, although some of the poorest countries in the world we actually have bilateral agreements with, particularly Mali and Bolivia, which are two of the poorest countries in the world. The one bright light is that several countries, just in the past 2 years, have in fact ratified the convention, including the United Kingdom, Switzerland, and Japan, which with the United States are the largest market nations in the world. Okay, that brings me, finally, to the subject of Iraq. And obviously, I have to cover this in a fairly abbreviated fashion. But I'm going to assume that a lot of you are familiar. I always start this part with a map, just in case. Lawyers never know. You can't be sure they know where Iraq is located. But of course, Iraq, most people today do know where it's located. And this was where the ancient Mesopotamian culture and civilization existed. And of course, we're talking about the land between the Tigris and the Euphrates rivers. This is a fairly old map, but it gives you some idea of some of the important ancient sites. And there you have a view of the Tigris River. And of course, Mesopotamia was the location of many firsts in the development of culture and civilization, including the first writing, the first agriculture, the first organized city-states, and also of importance, the first legal codes. And we see here the Code of Hammurabi, which was not the first legal code, but it is the best known early legal code. Now, the story of what happened in Iraq in some ways has to go back to the 1990 war. And immediately after the 1990 war, there were the uprisings, as you're probably familiar with. I should say the 1991, the first Gulf War. And many of the regional museums were looted in the uprisings after the first Gulf War. And these 9 out of 13 of the regional museums were sacked. And about somewhere maybe 3,000 or 4,000 objects were stolen out of the regional museums. Many of these were documented, and about 30 or 40 have surfaced on the market that we know of. But this began a realization amongst Iraqis that these objects have a great deal of value on the international market. Until the late 1980s and the early 90s, the Iraqi Antiquities Department was a model to antiquities departments through much of the world. Had been set up, in fact, by the British, particularly Gertrude Bell, in the 20s and the 30s. And until at least the late 80s, and particularly the time of sanctions, there really was not much of a problem of looting sites. But after this experience of the looting from the regional museums, sites did begin to be looted. And we see here just to illustrate, one illustration of this. This is a wall relief from the site of Nineveh, Neo-Assyrian site. And you see here one of these warriors. Here, this was documented by Professor John Malcolm Russell in 1988 and 89, right before the first Gulf War. A few years later, he was shown this fragment, which is the same fragment of the piece I'd shown you before. So again, this piece had been chiseled off of the wall, the sculpture relief, and he was shown about 10 of these, and he was shown it by dealers and asked whether these are legitimate legal objects. Of course, he told them no, but at that point the objects disappeared, and we don't know where they are today. So that's just one example of the looting of sites in Iraq during the 90s. Now, before the second war started, before the second Gulf War started, in the weeks right before the war, the Iraqis themselves did take measures to protect objects. And some of the best known pieces, this is the head of Sargon, or perhaps Sargon, which is emblematic of the pieces that were removed from the museum and placed into storage and are still in storage still today. I assume most of you are familiar with the story of the looting of the museum in the middle of April in 2003. This is the base of the Warka vase as it appeared actually a couple of weeks after the looting. This is the lyre from Ur, the late 3rd millennium lyre, as it's supposed to be. Now, in fact, the head had been removed and was placed in the bank vault. But this is what it looked like after the looting. So I can only show you, just give you a brief idea, but I'm sure you have a sense of that. I want to mention, there's the Warka vase that was returned. Okay, I thought I'd lost my other pieces there. Of the about 45 or so sort of highly recognizable, well-known pieces were stolen, including the Warka vase, probably the best known. Some of these were recovered. About half of them were recovered in the months up to a year or so after the looting of the museum. Other very well-known pieces, such as this ivory, Nimrod ivory, has still not been recovered today. In addition, a total of about somewhere between 13,000 and 15,000 objects were looted from the museum. About almost 5,000 of them were cylinder seals. When you see here an example of a cylinder seal. So I've been told that these 4,000 or 5,000 cylinder seals would all, I don't know if they could really all fit in a backpack, but that's what I've been told. I can ask Piotr if that's correct or not. These can sell on the market anywhere from a few hundred or $1,000 or $2,000 up to $200,000 or $300,000 or $400,000, depending on the individual piece. The ones taken from the museum were not the highest quality, so you're probably not talking about $400,000 a piece. These, by the way, are not from the museum. This is just a random picture of a cylinder seals. But you get some idea of the value of the pieces. What else happened? Something that has not gotten nearly as much attention was the other cultural institutions in Baghdad that were looted and some of them burned, including libraries and archives. You see here the inside of one of the libraries. Here again, where manuscripts and books were piled up and set on fire. So this is a much bigger problem than just what happened in the Iraq Museum. Now, what's the story today in addition to that? The biggest problem today, and has been going on even since before the war started, is the looting of archaeological sites themselves. This is the site of Isin in southern Mesopotamia. This picture was taken not too long, about 2 months after the war itself in 2003. And you see here the looters working at the site. And a close-up, this was taken by, I think it was Professor McGuire Gibson who took these pictures. And he went accompanied by the US military, and when they would land in their helicopter, the looters would sort of run away. But as soon as the helicopter took off, they would just come back. There were 200 or 300 looters at this site working. And apparently many of the sites in southern Iraq have been almost completely destroyed. Archaeologists that I've talked to who've worked in Iraq are extremely discouraged and said that some sites really are completely obliterated at this point. Some other things have happened or surfaced. Information has come only recently. This is part of the Ishtar Gate from the site of Babylon, one of the best known sites in Iraq. The United States military apparently decided the best way to protect Babylon was to put a military base on top of it. And here you see the site with US soldiers. Here again. One other thing, but in building their site, they dug down, in building the military installation, they dug down into the site, and they have destroyed a lot of the site. And they also built a helicopter landing pad, which you see over here. And to do that, apparently they sheared off the tops of the hill and just threw it all on the side. And the helicopters keep landing and taking off, which is also further destabilizing the site. We have a big outcry has been raised. By the way, these slides are courtesy of Professor Zaina Bahrani from Columbia University. And she spearheaded an attempt to work out an agreement with the US military to get this installation removed. And they have promised to remove it by December, but they promised it before, so we're not sure whether that's going to happen or not. The other thing that's come to our attention, this is the site of Hatra, Parthian site. It's one of the 2 sites in Iraq, which is a World Heritage Site. And we learned not too long ago, apparently the US is setting off, detonating in controlled detonations, military ordnance right nearby, which again means basically they're exploding bombs and things like that that they find. This again is destabilizing the site, potentially, and again we are trying to get them to stop doing it, but so far we have not succeeded in that. The third thing that I learned just the other day, this is the mosque inside the city of Najaf, which of course I'm sure you heard about. There was a great deal of fighting in the vicinity of the mosque just in the last couple of weeks. But apparently, just in the last couple of days, it was announced that the old city of Najaf, which I don't have a picture of, is going to be dismantled by construction companies. with American money. It's not an American construction company that's doing, but with U.S. government money. And again, this points out that there has been really no provision made in U.S. construction work that is done. Not that much reconstruction work is going on right now because of the security situation. There are very few provisions for carrying out what we call cultural resource management, which means basically survey and excavation and relocation of projects in order to avoid damage and injury to cultural sites. So all of these are problems that we can see in terms of Iraq today. Now, in terms of evaluating what happened in Iraq against the international conventions and the legal principles I set out earlier, I've already alluded to a lot of it. Under the Hague Convention, the US and the UK are not parties, so we pick and choose what we follow. It's unclear whether the Hague Convention imposes an obligation to prevent theft, looting, and vandalism by local populations. It's unclear when the obligations of occupation actually become effective. There was a UN Security Council resolution which said that the US was officially an occupier from about May of '03 to May of '04, but today the United States is no longer officially an occupying power because we've turned control back to the Iraqis. And so in a way, that makes the American government less accountable than it was before, because it's easy to say, gee, you know, well, the Iraqis agree with what we're doing, therefore it's not a problem. I mean, whether it's free will is another story, but that's how the story goes. And as I said, the biggest problem is the failure to take cultural heritage resource management concerns into account. And there may be a great deal of damage which is done, even at this point. The other thing is, what's the response to the looting? I mean, in theory, objects looted from the museum fall into the provision I mentioned earlier, which prohibits the import of property stolen from museums that were inventoried in the museum collection. But the inventories of the museums were ransacked and looted, and there were many objects in the museum that had not yet been inventoried. So that creates problems of documentation. Even if you want to get them under ordinary theft, there's a problem of documentation. Secondly, looting from archaeological sites. The only way to get at this is either through what I mentioned before, bilateral agreement. Both Iraq and the United States are parties to the UNESCO Convention. But Iraq has to bring a request to the United States to do this, and has not yet been able to do so. Furthermore, Iraq has had a national ownership law in place since 1936. But again, the onus falls on the US government to prove exactly when the object left Iraq, because if it left before 1936, then it's not considered stolen property. So the burden falls on the US to establish exactly where the objects came from and when they left Iraq, all of which makes it very difficult to pursue a case. Okay, I'm going to turn back then to talk a little bit more about the rescue narrative, and most importantly, I think, since this is a museum studies program, talk a little bit about the role of museums. And I'm just putting up a picture of the Parthenon Metope here, just so you have something pretty to look at while I'm talking. The rescue narrative resurfaced with great vigor in response to the cultural devastations in Afghanistan and in Iraq. Soon after the destruction of the Bamiyan Buddhas in March of 2001, Dr. James Cuno, who was then the director of the Harvard Art Museums, published an op-ed piece in the Boston Globe. Under his leadership, the Harvard Museums had already been criticized for acquiring questionable antiquities, despite an acquisitions policy that mandated otherwise. Cuno wrote, "Some argue that free trade in cultural property only encourages looting and pillaging of archaeological sites. But when an ancient object is offered to a museum for acquisition, the looting, if indeed there was any, has already occurred. Now the museum must decide whether to bring the object into its public collection, where it can be preserved, studied, and enjoyed, and where its whereabouts can be made widely known. Museums are havens for objects that are already, and for whatever reason, alienated from their original context. Museums do not alienate objects. They keep and preserve them, holding them in public trust for future generations." The rescue narrative and its implicit criticism of the governments of those nations that are rich in cultural and archaeological resources took on greater stridency following the events in Iraq, with titles such as, "What Were All Those Objects Doing in Iraq Anyway?" and "Maybe Lord Elgin Got It Right." Articles in the public press, written largely by dealers, propounded that the archaeological objects housed in the Iraq Museum should not have been there, especially as this is a part of the world prone to violence and war. Rather, these objects should have been distributed through the international market to those with the most financial resources to care for them. It is in fact ironic that it was actually the steps taken by the Baghdad Museum staff that actually preserved most of the collection. When one looks at Cuno's and other statements, we see that the rescue narrative fails to recognize the connection between the acquisition of unprovenanced antiquities and the destruction of archaeological sites. He said, you know, objects that have been already alienated for whatever reason. I mean, we know the reason. Those statements pay lip service to the issue of site looting, but then go on to deny the connection between the market and the looting. They denigrate the role of museums as educators of the public by focusing on a narrow definition of their role as preservers of physical objects, while ignoring the full historical, cultural, and educational context of these objects. This brings me to my final points concerning the role of museums in the cultural heritage debate. Museums and other public educational institutions have a particular responsibility to play in eliminating the pillage of sites. As was previously explained, the controlled excavation of sites is primarily of educational, scientific, and historical value. Museums must take seriously their role as educational institutions. To accomplish this, museums must do more than follow the minimum that the law requires, in particular because differences among legal systems too easily allow title to stolen property to be laundered. Ethical codes of conduct, particularly for acquisition, should establish these higher standards. The Code of Ethics of the International Council of Museums does this by stating, museums should recognize the relationship between the marketplace and the initial and often destructive taking of an object for the commercial market, and must recognize it as highly unethical for a museum to support in any way, whether directly or indirectly, that illicit market. The ICOM Code calls on museums to limit acquisitions to those objects that have been legally acquired in and exported from the country of origin, regardless of their legal status in the country where the museum itself is located. In contrast, the two leading museum organizations in the United States, the American Association of Museums and the Association of Art Museum Directors, largely sidestep this issue in their respective codes. Neither code addresses the questions of illegal export from the country of origin or of illegal excavation, relying solely on the minimum that U.S. law requires. They also seem to permit museum directors to act out of willful ignorance, forbidding only those acquisitions which the director knows are illegal. A new statement on the acquisition of antiquities published by the AAMD this past June adds little to what the law requires. It states that even if the museum cannot obtain sufficient information to determine whether the proposed acquisition, quote, would comply with applicable law, the museum can proceed with the acquisition, quote, recognizing that the work of art, the culture it represents, scholarship, and the public may be served best through the acquisition of the work of art by a public institution. I might add that about the same time the acquisition of a bronze Apollo statue was announced by the Cleveland Museum of Art, whose director was involved in the drafting of the AMD's new statement. This acquisition was from the Al-Boutam brothers, who were two dealers in New York, one of whom had just pled guilty to a misdemeanor, to a charge of improperly importing an antiquity from Iran. And I should add the other brother was also convicted in absentia in Egypt for dealing in stolen antiquities. I should also add the Kimball Museum, which is in Dallas or Fort Worth, had just finished being sued actually by the Al-Boutams because they acquired two different antiquities and decided to return both of them because of their shady background. And the Al-Boutams had turned around and tried to sue the museum to force the museum to go through with the acquisition. And in fact, when the Cleveland Museum purchased this bronze, did not ask, at least in their public statements, they said did not ask who the prior owner was. They had some information about where it was located in the early 1990s, but did not ask who it was acquired from, and did not seem to have obtained any documentation. This does not bode well for the AMD's new statement on the acquisition of ancient artifacts. Both museums and private collectors are acquisitors of cultural objects through the market. Museums acquire objects not only directly through purchase, but also through donations from private collectors and through loans and temporary exhibitions. Unlike private collectors, museums, however, are public charitable institutions with the purpose of furthering educational and scientific values. As such, the museum and its board of trustees owe a fiduciary obligation to the public. When the museum ignores the educational and scientific value of cultural objects, then it is committing a breach of these obligations. I would suggest that when a museum must return an antiquity to its country of origin or stolen work to its owner, the museum trustees should be held accountable if the loss was caused by the failure to adopt and implement an ethical acquisitions policy, one devised to avoid these very types of losses. This leads us finally to the necessity of fostering a new culture of collecting, one which focuses on the full story which objects can tell. In the past, the major museums of the world built their collections primarily through the art market, either as direct purchasers or as recipients of donated objects. A major step in altering this culture of collecting would be to place a moratorium on the acquisition of antiquities, or at least on the acquisition of antiquities without an ironclad pedigree. Such a moratorium would grant the time, space, and funds needed for museums to examine their own collections and to develop cooperative arrangements with both foreign museums and with smaller museums in the United States. It would likely also create a deterrent to private collecting if collectors could no longer be assured of a sizable charitable tax deduction and the prestige that accompanies such donations. The future museums should seek an alternative based on loans and exhibitions which are grounded in interinstitutional cooperation. Although ownership of objects may have seemed to provide permanence to collections, this is questionable. That museums are capable of such a significant change in attitude and management is demonstrated through the changes with respect to Native American materials. These changes were largely forced on museums through passage of the Native American Graves Protection and Repatriation Act in 1990. NAGPRA requires all museums and universities that receive federal funds to prepare inventories of human skeletal remains and associated grave artifacts in their collections, and summaries of unassociated grave artifacts, sacred objects, and objects of cultural patrimony. These inventories and summaries are given to descendants or Native American tribes that are culturally affiliated with the remains. The tribes are then able to request repatriation, and in most cases these requests are then resolved either through direct negotiation between the tribe and the museum or with resort to the NAGPRA Review Committee. In only a very small number of cases have the parties resorted to litigation in court, and even these were eventually settled. Even more to the point, despite dire predictions, museum collections have not been emptied. It is very difficult to determine how much has actually been repatriated because these statistics have not been maintained, but there is a general consensus that not much that was formerly on display in comparison to the amount of material in storage in collections has been repatriated. At the same time, the NAGPRA inventory process has forced museums to study their collections more carefully than had been done previously. Under the impetus of NAGPRA, which has sometimes been called the Full Anthropologist's Employment Act, under the impetus of NAGPRA and despite the negative publicity generated by the recent Kennewick controversy concerning the disposition of a newly discovered ancient skeleton, museums today are engaging in constructive dialogue, albeit sometimes with tension, with the Native American communities. This has provided the cultural context which was often lacking before, and through cooperation, advances have been made in knowledge of the archaeological and cultural record. Parallels between NAGPRA and international agreements such as the UNESCO Convention have been noted in that both mark a shift in the balance of power. This leads to the necessity of establishing collaborative arrangements, which often turn out to be beneficial to all. An approach based on a spirit of cooperation in the field of international antiquities will also bring comparable advantages. First, it ensures that the world's artistic and cultural heritage really does circulate throughout the world, rather than remaining in a few well-endowed institutions and private collections in only a few countries. Second, it allows these institutions to move away from reliance on the market, which is often furnished aesthetically pleasing, costly but unprovenienced objects whose story is muted for lack of scientific and historical context. Third, it permits the museums of Western Europe and North America to enter into mutually beneficial partnerships with the institutions and governments of other nations, rather than perpetuating an antagonistic stalemate. Exchange of objects allows sections of the same objects or several objects that were originally part of a single corpus to be reunited. It also allows objects to be viewed through new eyes, and not only have advances in conservation techniques resulted, but new discoveries have been made when objects are placed on loan with different institutions. Professor Willard Boyd, former president of the Field Museum of Natural History in Chicago, has described this needed transformation. Traditionally, museums have stressed the benefits of the movement of objects without adequate regard for the detrimental aspects of movement from the point of view of others. Certainly, the cross-cultural transfer of the human ideas surrounding objects is regarded positively in an age of communication. However, the movement of objects that results in cultural and environmental loss, destruction, and desecration cannot be justified. Museums must realign their acquisition and retention policies to promote cultural understanding and respect for the objects and ideas of others. An ethical attitude requires that we do so. At this point, I must also refer to the role of education in causing change. The legal system provides a short-term fix through imposing adverse consequences and disincentives for engaging in conduct that is destructive to the cultural heritage. Education is the longer-term solution. Education of the public in market nations, and education of the public in the culturally rich nations. Cultural heritage resources in such nations should help provide sustainable economic development so that impoverished people will no longer need to rob from their ancestors to eke out a living today. Archaeologists and others must take an active role in this educational process. They need to publish the results of their research and education and excavations. They need to publish them in a way that is understandable and meaningful to the public. They also need to publish their results in the local languages of their host countries, and they need to work with local communities. Finally, archaeologists must become activist advocates for cultural heritage preservation and catalysts for change. This change of attitudes in both market nations and nations that are rich in cultural heritage resources is the long-term solution and is the only one that will really work. Through these changes in public attitudes, the world's cultural heritage can be preserved for our benefit and for the benefit of future generations. Thank you. I made it in under an hour. So anyone who wants to leave and get home in time for the debate can do so. If anyone has questions, yes, I'll be glad to take them. Yes?
Might as well start. I really appreciate your enumeration and your outlining of the legal structures here. What intrigues me though and worries me, I guess, is the notion of a state or a government owning this property has implicit within it a notion of sovereignty. And sovereignty generally, once recognized, whatever that means, once recognized, a state has the right to dispose of these goods as they want. The scenario in the Iraq case that you offered raises a specter that frankly is not beyond my imagination, in which a government appointed by an occupying army claims sovereignty, and then can, under that sovereignty claim, though they are indeed a cardboard regime, they can then presumably legally start disposing of the cultural assets of that country. In other words, the Alawi regime could presumably at this point just start selling that stuff off and dumping it on the market. Is that true?
Well, it could.
I guess the question is, how does sovereignty work into this, and who decides what a legitimate government is that can dispose of these assets?
Well, oh boy, I mean, the tough question I thought you were going to ask, which would have been simpler. But I mean, the basic idea is, I mean, if you think of, for instance, what the Taliban did in Afghanistan, where they intentionally destroyed objects. The problem is that there is no international mechanism to stop that.
Right.
There was a great deal of public outcry. UNESCO, Pakistan, other countries that they thought Taliban might listen to, all tried to stop them, and they wouldn't stop. So to me, that's a major flaw in the international law. Now, in terms of, because we have no enforcement mechanism. Right. I mean, there are statements, there is the Hague Convention, things like that, that theoretically impose obligations on governments to preserve and protect cultural heritage. But it is without any enforcement mechanism. Right. And one of the tricky parts would be finding a way. I mean, the talk I gave tonight is sort of the skimming of many different talks I could have given, each of which would have been an hour. And I could have said a lot more about sovereignty and nationalism. And many academics in particular don't think much of nationalism and sovereignty. They're sort of in a post-nationalist world. Some academics, sort of from a leftist critique. Nationalism is a critique from sort of a more conservative viewpoint, and it's also a critique from a more sort of liberal, post-nationalist critique. But in this area, I think it's very dangerous to denigrate sovereignty, because then you would undercut the ability of the nation to protect heritage. Now, what do you do when a nation doesn't protect heritage there's not much we can do except through public pressure? And that's part, again, where education would come in. Presumably, if the people of a country get a say in their own government, then they should try to stop that. Now, the other question is the Alawi government a legitimate government in Iraq? I mean, that's kind of a different question. Certainly, following this UN Security Council resolution in May of 2003, the US government, or the coalition, was recognized as legitimate sovereign. And the position of the US government was that they could do anything that a government in Iraq could do. At this point, I'm assuming at least the position of the United States is the Alawi government is a legitimate government, since June 30th, and can do anything that any other sovereign government can do. So there really isn't anything other than public pressure to stop them from doing that. And in fact, there have been things brought out of Iraq that really should not have been brought out of Iraq. Whether it's, No, before that even, like military memorabilia and stuff. I mean, not antiquities so much. There is a story that actually a cache of manuscripts was taken, Jewish manuscripts were taken out of Iraq. It showed up, there was one little article about it in the New York Times last summer, not summer of '03, that was taken unilaterally by the US government out of Iraq for purposes of preservation. And it's been fairly controversial to those, not many people know about it, but to those who know about it, it's been pretty controversial. The other problem I'll mention briefly about Iraq is that, you know, there's a lot of discussion about how Iraq could possibly split into three, you know, that under the Ottoman Empire it was in three sort of provinces. And this sort of delegitimization of Iraq as a modern nation state, or as a single nation state, could also undermine its claim to recover archaeological artifacts or other artworks and cultural objects that are looted, because if it's no longer a legitimate state, I mean, who has the right to claim it becomes a question as well.
Did you run into, just if you don't mind, is part of the issue here also that the archaeological sites would cut through the presumed three provinces as well? So there
might be. I mean, well, you'd have to prove which. Well, they could perhaps come together. I mean, we had this problem when Yugoslavia broke up. But for instance, there was a case I didn't mention where there was a treasure. It was a Roman silver called the Sevso treasure, which was taken, probably came from Hungary, but was claimed by actually 3 or 4 different countries. It showed up in New York. It was put on the market to sell, worth something like $50 million or whatever, allegedly. And some British lord bought it, and they sent it to New York. Sotheby's took it to New York to sell. And these countries tried to claim it back, and no one could prove which country it actually came from. They knew it came from one of them, but they couldn't prove which one it actually came from. And so the court refused to give it back because they couldn't carry their burden of proof. So in all of these cases, there's a burden either under the civil standard, which is a lower standard, or certainly criminal prosecution, which is a higher standard, to prove where it came from and when it came out of the country, which is a difficult case of archaeological artifacts. It's very difficult because it could become from, you know, there's another problem with the nationalism, national ownership, sovereignty issue, which is, of course, modern nations are not congruent with ancient cultures. So, you know, you have the Roman civilization. This could have come anywhere from like 40 different modern nations. So you got to prove which one it actually came from. And the problems also occurred with like the Inca culture, which spreads across Peru and Bolivia, and the Maya culture, which spreads across several Central American countries. So reliance on the nation state is far from perfect. And I think we need to try to find a way of keeping the authority of the nation state while also in some way transcending it for certain purposes. But right now it's too dangerous to do that because you can end up undercutting the whole notion of national ownership, which I think would make it even worse. Other questions, or have I put everybody out, or you all want to go hear the debate? Go ahead.
Well, even if these measures were instituted and people started behaving themselves, we have the interesting problem of what should be done with everything that has been stolen in the last 20 years and is sloshing around the art market, things that have never been documented. What country would get it? How would anyone, you know, where should it go?
Well, I mean, I would prefer to see objects in museums as opposed to private collections, because in museums there is the chance for the public to see and learn about the object. There was a suggestion made, and I included a little bit of it in my talk, by Professor Coggins. She made about 5 or 6 years ago, which is this idea of moratorium on collecting by museums, but that basically people who there would be also an amnesty. People who are currently in possession of objects could come forward. I don't know if this would ever happen, but part of it would be that they should show as much documentation as possible at the same time, because actually there probably is more documentation on these objects. One of the market criticisms of my approach is that it's in their interest now to obscure where these objects actually came from. So for example, in the case of this Roman treasure art I was talking about, they did know where it came from. And in fact, today we pretty much know where it came from. But it was in the interest of the people trying to sell it to obscure that. So they got a forged Lebanese export license to try to prove it actually came from Lebanon, but it really came from Hungary. And so there would be a great interest in trying to have this documentation come out along with it. And the question would be, what inducement could you get people to come forward with it? I should say my view, and the view of many other people, is that I don't really care where the object is today from sort of an abstract point of view. I mean, once it's been taken out of its original context, and that, you can't ever put it back in the archaeological site. So it's gone. That context is gone. The reason why I favor repatriation or restitution today is as a deterrent to future people from doing the same thing. If Michael Steinhardt loses $1.2 million, or the collector who bought this Iranian piece I was talking about loses $950,000, or the Metropolitan Museum loses many millions of dollars when they had to return what was called the Lydian hoard to Turkey, one hopes that that kind of financial loss, or when Fred Schultz ends up in a federal prison for 2 years for dealing in antiquities from Egypt, one hopes that will have a deterrent effect on future conduct. So in that case, that's why I support repatriation, not because I think all objects really have to be in Egypt or wherever, although I think they deserve to have representations of their own culture locally as well as in other countries. I think the deterrent effect brought by restitution is very important. It's the only way to conform future conduct.
With that, I was just wondering what the practical, I suppose you're
We're so far away from the idea that all those objects are going to...
Bringing some documentation would allow sorting out where things ought to go back.
Or that some of it could stay in other countries. I mean, it could stay in the United States, perhaps. It would depend on how much the country wanted. If you knew what the country of origin was, it would depend on what that country would want. I don't think that countries like Greece and Egypt actually want everything back. They want some things back. I don't think they want everything back. And that's one of the statements that's been circulated. Like if we give back the Parthenon sculptures, they're going to want everything. The museums are all going to be emptied. I don't actually think that's true. So they would, and it would depend on what country. I mean, there are countries in Africa that have no representations of their culture. They're all in the British Museum, the Metropolitan Museum, or Paris, or whatever. And I think those countries certainly deserve to get back. But legally, it's not going to happen as a result of legal action, because each of these lawsuits takes years and is very expensive to prosecute. You only do it when you have very tight case and the objects are singularly important objects. You're not going to go after every Greek vase that's wherever. So I don't know if I've answered your question yet, but I haven't worried too much about what to do with all these objects, because I don't think we're ever actually going to get them all and then have some arbiter decide where they should go. I just don't think it's going to happen. It might be nice if it did, but I don't realistically think it will. Yes?
What's the current state of the bills before the House and the Senate regarding protecting
Iraqi cultural heritage? Okay. I should mention right after the looting of the Iraq Museum, well, 2 bills were introduced in the House and then 2 bills in the Senate. And the ones in the House were much broader. They tried to amend our implementation of the UNESCO Convention as well as deal with the Iraq situation. The bills in the Senate only dealt with imposing import restrictions because we realized that Iraq could not bring a request under the circumstances there. I'm sure the 2 bills in the House are dead. And the earlier bill in the Senate was replaced because it was the same author. And it got tacked onto something called a miscellaneous trade bill, which is about 130 pages long, and the Iraq provision is less than half, about a third of a page. Now, that's being held hostage not for any reason that has anything to do with Iraq. It's being held hostage because the Democrats in the Senate are refusing to. There was a version of the bill passed in the House, a version of the bill passed in the Senate, and then they have to go to conference to work out a single bill. And actually the House has, and the Iraq provision is only in the Senate version. And the House committee has agreed to accept the Senate version of the bill. There's all this agreement. But it can't actually move forward without this conference. And the Democrats in the Senate, who are mad for other reasons, the way the appropriations bill passed last year, are refusing to appoint conferees. Congress is scheduled to adjourn next week, as far as I understand. Everyone wants to go home and get ready for the election. But unless the appropriations bills are passed, then Congress will come back probably after the election. So now, if the bill isn't passed by December, it will automatically die and will have to be reintroduced. As of right now, the prohibition on import of objects from Iraq is being perpetuated through an executive order pursuant to something called the International Economic IEPA, International Economic Emergency Powers Act, which gives the president the authority to put out an executive order which imposes the sanctions on Iraq through the 90s and the sanctions on Iran and all this are through this mechanism. So right now there are sanctions still in place on goods being imported from Iraq, but it's a very small category, but includes the Iraqi cultural or legally removed Iraqi cultural materials. And there is a UN Security Council resolution which calls on all UN member states to prohibit trade in illegally removed Iraqi materials, and it's done under Article 7 of the UN Charter, which means it's binding on all members of the United Nations. So that's the status. We hope legislation will be passed no later than next August, which is when the president would have to reissue, I was going to say President Bush, but when whoever the president is will have to reissue the executive order. So that's where it stands. It's a question of politics. It has very little to do with Iraq at this point. And I guess speaking of politics,
for those of you who are able to stay, I'd like to invite you to join us in the back for coffee, tea, and cookies. For those of you who can't stay.
We'll be back here.